Hello, Legal Naya here. Welcome to my YouTube channel. If today is the first time you are watching any of our videos, want to say please subscribe, like and share our video. If today is the second time, third or fourth time you are watching our videos, if you're a returning viewer, want to say thank you for watching our videos, which keeps on encouraging me to continue to bring you videos on the law. I have received a couple of emails concerning people's problems who want to seek legal advice on these problems. So for the next couple of weeks, I'll be reading these emails and we'll learn the law on their problems together. So today we are taking the email from me. I read, "Hi Legal Naya. My name is Nee. I am 16 years of age. Last year, I lost my father. Oh, that's sad. I lost my father, and after the death and the funeral, the will of my father was read. When the will was read, my father gave all his properties to his extended family, that is my aunties and my uncles. My father did not make any provisions for myself, my mother and my younger siblings. Now I just gained admission to the university. We are finding it difficult to finance my education. I want to know, do I have any remedy, or can I go to my aunties or my uncles who my father has willed the properties to ask them to give me a share in the properties in order for me to further my education? I want to know what the law says and if the law makes any provisions for me." So that is me. In answering these questions and also us learning the law on Nee's problem, we'll first talk about what wills are. So wills generally talks about someone disposing of all his self-acquired properties, that these properties should be shared after his death. Now, one thing we should know is that every person is at liberty to make a will and share his self-acquired property in a manner that he likes. So there is no law that prevents a person from sharing his property to the people he likes. There are times where you realize that from a will, a person has given all his properties to his side chick. His wife didn't get any property. There are times where you find a woman also giving his properties to his boyfriend. We find situations where people even will all their properties to a church or to a particular religion they belong to. Now, the law does not prevent anybody from willing his properties in any manner that they want. So you choose to share your property in the way you feel like and the way you want. Section 1 provides that the person making the will should be 18 years and above and should be of sound mind. So once the person meets the requirements of a will and the person was said to be of sound mind, any person he has made a will or a deposition to, he has given properties to, the law is not against it. The law is supposed to honor that person's wishes. But one thing we know is that under Section 13 of the Wills Act 1971, the law makes provisions for dependents. Now, here is where this question comes in. Let's listen closely. Section 13 provides that a person can make an application to the High Court where after a will has been read, the person is a dependent and the testator did not make any reasonable provision for that dependent in his lifetime or even in his will for the maintenance of that person. So now let's take it again. So Section 13 provides that where a person dies and the person did not make any reasonable provisions for a person or a dependent during the time of his life or even in his will, he did not make any reasonable provision for the maintenance of his dependents. The dependents can go to the court for an order to be made for a share of the property to be given to him. Now, when we talk about dependents, the Wills Act defines who the dependent is in accordance with Section 13. So this is what Section 13 says. Section 13 provides that the dependents in this situation are the father, the mother, the spouse, and a child under 18 years who provisions have not been made for that child. What we have to know is that where a child is under 18 years and provisions have not been made, that child can go to the High Court for a provision to be made for him under his father's will. Let's listen to this part very well. This application can be brought at least within 3 years after the probate has been granted. Within 3 years. Now, this is where you should be very careful. You cannot sit down and wait after 6 years, 7 years and say that provisions have not been made for me, so I am now coming. No, the law provides that within 3 years after the probate has been granted, you should come to court, get a lawyer, let the lawyer make that application for you and tell the court that I have not been given any reasonable provision in his will, or this person did not make any reasonable provision for me within the time of his life, and this is the person I depend solely on. He is the person who was maintaining me during his lifetime. Now, this is the orders that the court can make. So people will ask, so what will I get? Will they go and take the property from me? These are the things, the 2 orders that the court can make when you make such an application. 1, the court can ask a lump sum of the properties in the will to be given to you. So he can make an order that this particular sum of money should be given to you. 2, the court can also provide that an interest in a particular property should be given to you because you would maintain yourself with that property. Now, let's go to Ni's case. In his case, he's less than 18 years. So he meets the criteria where it talks about a child under 18 years. Now, if your father did not make any reasonable provision for you, reasonable provision. So let's say your father did not, so from his email, you can tell that his father did not even make any reasonable provisions for himself and his mother. Now, here is what you are supposed to do. You are supposed to get a lawyer. Let the lawyer help you make an application to the High Court for you to tell the court that your father has given all his properties to his relative, his extended family members, and now he is the person that was maintaining you, and you need this money to pay your fees, and that you need part of the properties to maintain yourself. This is the little advice we'll be learning, or the little legal tips we'll be learning today. Today we have learned that if someone dies and makes a will, and the person does not make provision for his dependent, you can go to court for an order to be made for you, for a lump sum of money to be given to you, or an interest in any immovable property to be given to you in order to maintain yourself. So Ni, thank you. I hope you watch this video and you take the necessary steps that you are supposed to take. Thank you so much for watching this video. Until next time, thank you. Bye from Legal Naya.